All right, committee, welcome back to another day of the House Judiciary Committee. We've got a few more Senate files in front of us today yet, and probably a few more to go before we finish out the week. Carol, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
I'm here. Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Here.
Vice Chair Washit.
Here.
Representative Yen.
Here.
Representative Zwanesser. Chairman Olson.
Here.
All present.
All right. We will begin our work with this nice, clean, white Senate file. That's unusual. Senate File 68, Decentralized Autonomous Organizations Amendments. Committee, this bill comes to you sponsored by the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. We introduced the DAO to Wyoming last session, and now we're just doing some updates, many of which we actually anticipated and intended, or at least thought about, contemplated in that bill. But timing wasn't our friend. But we do have one of our governor appointees to the Select Committee, Matt Kaufman, who will walk us through the bill and is really the one of the brainchilds and hardest workers on the DAO that we have on the committee. Welcome, Mr. Kaufman.
Thank you, Mr. Chairman, members of the committee. My name is Matt Kaufman. I'm a partner with Hathaway and Coons, and as Chairman Olson just said, I'm a appointee to the Select Committee. Mr. Chairman, I'll go through this as quickly or slowly as you want. On the Senate side, they wanted the quick version. So you tell me, Mr. Chairman.
You know, Mr. Kaufman, did this go through Judiciary on the other side? Or?
No, it went through Minerals, Mr. Chairman.
So yeah, they're okay. All right. Well, you can walk us through it. We only have 2 Senate files, and
Okay.
I think it will be helpful.
Feel free to speed me up, Mr. Chairman.
You bet.
So for members of the committee, just as Chairman Olson was saying a moment ago, to refresh your memory, last year we created a brand new subtype of LLC in Wyoming called the DAO, the Decentralized Autonomous Organization LLC. This is a brainchild of the blockchain ecosystem and sort of, I guess, a new way that people are forming businesses on a blockchain where the interests of the parties are represented through common assets or common governance that's exercised on a blockchain. And so thanks to you all, and thankfully to the committee, Wyoming is the first place in the world to do this. It's been amazingly popular this last year. Last year, mid-session, we realized that there were some cleanups that need to be made, and a lot of these just didn't get done in time, as Chairman Olson was saying. So a lot of this has been percolating for a year. But over the course of last year, we've been able to engage pretty much all the stakeholders that have come to the table with respect to the DAOs, as well as many of the companies have filed some of these brand new ones starting in July, just to kind of clean up some of the language that creates a little bit of confusion with respect to the entity type and how it works. And so pretty much everything today, there's only 1 or 2 points, and I'll point those out where we've kind of made a substantial departure from what we did last year. And there's logistical reasons behind that, and I'll explain. But for the most part, we view it all as cleanup. With that, Mr. Chairman, I'll turn to the bill. Starting on page 2 under the definitions. This is one of those things I would categorize as cleanup under majority of the members. So just as a quick refresher, in Wyoming, we have predominantly 2 types of LLCs, member managed LLCs and manager managed LLCs. These DAOs are organized such that they can really only be member managed LLCs. As such, we had defined in the original version what a majority of the members means. What we realized is that created a few issues with respect to how we defined quorum, which we have now determined is probably an unnecessary definition. So the new language, I can read it for the committee if you want. It just means more than 50% of the membership interests eligible to participate in a vote, or any membership interest required pursuant to the DAO's Articles of Organization or Operating Agreement. So again, pretty simple, clean definition, just meant to get rid of that quorum concept. Moving down to subparagraph 4 on page 2. Again, just cleaning up the definition of what membership interest is in a DAO. getting rid of improper references to a share. Share would refer to corporations, and LLCs would refer to membership interests. And getting rid of any mention of member managed DAOs. That was one of the confusions I think we inadvertently created in the bill. Is there's a few places where we reference algorithmically managed and member managed DAOs. People thought we had two different types of DAOs, which was not the intent. We just have one type of DAO. So again, that language was simply aimed to clean up that confusion. Moving on to subparagraph 9 on page 3, we have a small cleanup in the smart contract definition. Again, as a refresher, smart contract is something that you all have already defined in our UCC addendum and property amendments. And so this new DAO entity incorporates that smart contract definition. However, what we heard in a lot of our testimony was that definition for purposes of application to the LLC might be just a tiny bit more narrow than we should have had it or that we intended to. So this just intends to broaden that language. So again, the language would now say smart contract means an automated transaction as defined in Wyoming statute, or any substantially similar analog or code script or programming language relying on a blockchain. Fair warning, I think at some point in the future, we may be visiting whether or not we should even mention blockchain in this. We did hear some testimony on that. I could see that as a future amendment. But as we know, the technology today, that was the best language we could do. Moving on to page 4, 1731-104. Again, this is in reference to that comment I made a moment ago about our inadvertent confusion referring to two different types of DAOs, a member managed and an algorithmically managed. So this was another one of those places where we cleaned the language up to help clarify that there's just one type of DAO. So in this provision, it says a statement in the articles of organization shall establish how the DAO shall be managed by the members, including to what extent the management will be conducted algorithmically. So again, just I think substantial cleanup to that provision. Moving on to 1731-105 at the top of page 5. This is one of those two places that I would categorize as something brand new. And what this is in reference to is one of the things that we required as a policy measure in filing of the DAO is that you have to provide a public identifier for that blockchain or smart contract that you're going to use in the DAO. What the Secretary of State has since reported to us is they don't really have a good way to police that. And they don't really have a good way to tell if the identifier that people put in there is valid. The other issue they were having is people filing articles of organization for these and then saying something like the smart contract is to be determined or to be provided, which technically doesn't comply with the statute. So what the Secretary of State suggested to us is what if we have a 30-day provision in there where if the applicant or the filer refuses or fails to provide that public identifier within 30 days, we just reject the filing.
Yes, Representative Zwanzer.
Thanks, Mr. Chairman. I guess I'm confused. Why wouldn't you just reject it outright until they submit the requisite information? Why would you give it 30 days?
Mr.
Yeah,
Kaufman.
Mr. Chairman, a lot of the testimony we've heard, Representative, is that some folks, when they're filing these entities, it takes a little bit of time to generate that public identifier. And so if they want to maintain the liability shield and protection and have the entity be the filer and then establish the smart contract protocol or register the blockchain address or something like that, it creates a little bit of a chicken and egg problem. So this allows them an opportunity to file and then supplement with the public identifier.
I'll let you do it. Representative Grego.
Thank you, Mr. Chairman. Do we do that for any other type of LLC where we have a grace period on a filing?
Mr. Kaufman.
Yeah, Mr. Chairman, I'm racking my brain. For traditional LLCs, obviously, we just require, the name of the entity, the registered agent, the address. Trying to think what else is technically required by statute. Similarly with those entities, I mean, you could file with a temporary address or, any other information which can be supplemented later. But this is the only entity type where we have a public identifier.
Representative Zwanzer, follow up.
Yeah, thanks, Mr. Chairman. Just Is there a possibility, opportunity for fraud then? You commit or you have one, you can conduct business in those 30 days without all the necessary information, then you dissolve or you allow yourself to be dissolved. I guess were there any comments from the Secretary of State? They feel comfortable? I don't know if they're here today to present. It just seems like an interesting way to do business. And any more discussion on that, I guess, is my question.
Mr. Kaufman?
Mr. Chairman, I obviously don't want to speak for the Secretary of State's office. We did have a lot of conversations about this provision. I think the consensus between the committee and the Secretary of State's office was this solution probably reduced the opportunity for fraud from what we have now. And so we saw it as an improvement for sure.
And Mr. Kaufman, the other half to this is providing the SOS with a process, the dissolution process, if it's not provided, because they wouldn't otherwise they don't really have a mechanism. These just sit on the books with no public identifier.
Agreed. And Mr. Chairman, in response to that, I would remind the committee, even though we require the public identifier at law, we have no qualification as to what that public identifier has to be, right? And so one of the issues that we ran across is, I mean, we want the Secretary of State's office being in the position where they have to somehow go verify and check those blockchain addresses to make sure that they're valid. So this again was at least a way to create a threshold where that information has to be provided within a certain amount of time.
Vice Chairman Washington?
Thank you, Mr. Chairman. Mr. Kaufman, is there a way to verify whether that identifier is valid or not? Is there a test or a process by which you could do that? And I guess I wish the Secretary of State's office were here today, because I think understanding how they regulate all of this is a missing piece of what we've always experienced when we talk about blockchain topics in this committee is the Secretary of State's office is rarely here to answer these questions. So is there a process by which an entity could test the validity of these?
Mr. Kaufman?
Yeah, Mr. Chairman and Representative. So I would say a couple things with respect to that. One, yes, there are ways to test the validity. The problem is the blockchain space is vast already. There's a lot of different public and private blockchains available. There's a lot of different smart contract protocols on which something like this could be done. So the problem is the Secretary of State's office doesn't necessarily have the hardware capability or the software capability at any given moment, depending on what the technology choice of the company is. And so that's one of, I guess, the policy issues that we discussed with the DAO originally was these are designed right now, or the law that we've crafted is designed to be technology neutral. So we're not specifying what type of blockchain, what type of smart contract protocol people can use for the DAO. So that's one of the logistical problems. The other comment I would just make, and this is something that we again discussed extensively in the committee hearings, is this isn't a lot different than what regulatory purview the Secretary of State's office has over any entity now. If anybody files an LLC today, the Secretary of State doesn't have any special regulatory power to check and see is that entity engaging in legal activity or an activity that's properly regulated within the state of Wyoming. We simply police the statutory criteria that are put forth in the statutes upon filing, and then of course annual maintenance requirements for those entities. So we sort of discussed, and I think the committee landed on the fact that this is just one of those maintenance pieces. It's just a little bit different than the other LLCs, but we're not making any other policy choices.
Welcome, Ms. Wheeler. Just in the nick of time. Could you come up, Ms. Wheeler? Sorry, Mr. Kaufman. We just have, the committee may have other questions for you, but I think they have a really simple one now that would be helpful.
Good morning, Mr. Chairman, members of the committee. I'm sorry, I was in another meeting, so I just ran. Karen Wheeler, Deputy Secretary of State. And so I didn't hear the last few questions, but I can address the few that I did hear. As far as LLCs, Mr. Kaufman is right. There are 3 pieces of information that must be provided to our office: the name of the entity, the registered agent, and the organizer. And that is all that is required by statute. As far as the public identifiers, the problems that we were having is, as this is a new entity type, it's not your traditional like we're used to dealing with. And it does have just the public identifier, which is unique. And we had many DAOs file that they're just in the formation process. They didn't have the public identifier yet. And we had no means of giving them a grace period. It was either reject, come back and start over, or we gave them the 30 days to provide it. So that is why we had asked for that amendment to the bill, so that we could give them that opportunity to get, it's like a new business, get all their ducks in a row. And then they could provide that public identifier. And if they didn't, then we can administratively dissolve that DAO for not providing it. So I'm happy to answer any other questions. I'm sorry that I may have missed when I was running down here.
Representative Swanser, did you
Well,
have a
I guess
question?
the overall question for either one of you is, why are we being so darn nice? I mean, any other business, right? They have to have their ducks in a row before they come forward. Is it, these are complicated, and I know they're worldwide, and they're trying to figure out how to, it can't be they're trying to figure out how to meet our statutes, I don't think. It's just the way they incorporate is difficult. I guess I'm trying to figure out why we give them a grace period. I appreciate that we do, or we dissolve them, but why do we not demand, like we would any kind of more tangible LLC, that they come and have their ducks in a row before they present? And that might be a Kaufman question.
No,
Or it
please.
might be-
Who won?
I can take a stab.
Mr. Kaufman.
Yeah, Mr. Chairman, I think a couple things, again, back to the testimony we've heard in the committee about how a lot of these entities are being executed and how the people that are forming them who want to take advantage of the limited liability in the first place are creating and standing up these DAO wallets and the DAO property that they're coalescing for purposes of forming. And it's what we heard at the original testimony was it's really hard sometimes for them to simultaneously execute that where they have those addresses at the time of filing. And then I guess I would just say to piggyback off what Secretary Assistant Wheeler was just saying is that I think a lot of these entities, when they were coming to file, we didn't have a current way to either reject or accept that filing qualified on something. As I mentioned, we saw a lot of filings that were putting something in there to be determined or a placeholder. Again, that didn't really create a clean mechanism under the statute to accept or reject those filings.
Go ahead, Representative Swanser.
So then I guess my next concern, in that 30 days, they still have all full applicability to conduct business, hopefully above board, but perhaps nefariously. Are there still going to be any tools in place should you have a bad actor and they dissolve after 30 days that with the limited information, especially because these are probably global, that, I mean, does the SEC have we talked to the feds? I mean, do they have any concerns about having these kind of flash companies before you can dissolve them, that they can conduct business? And have we kind of got our ducks in a row with securities, et cetera, should something really bad happen, that we have authority, capability to turn over any information? Is there any concern there on enforcement for a bad actor?
Mr. Kaufman.
Mr. Chairman, and I can gladly speak to that. That's where I spend, unfortunately, a lot of my days these days. First of all, I would say that, of course, state entities and the authorization and organization of of entities is a matter of state law. So there isn't really a federal legal mechanism to police the entities themselves. With respect to the securities issues, obviously there are loads of securities issues. But again, the state of Wyoming has certain exemptions in place and statutes that control the compliance of securities participants. And then there's federal regulations as well, depending on the nature of the securities offering. So I couldn't even begin to tell you the complexities of these types of entities if they want to conduct securities offerings. That's a little bit of a different, I think, issue, though, with respect to the fundamental corporate law governing their organization.
Representative Yin.
Mr. Chairman, thank you. Maybe I can provide some clarity on both the DAO LLC as well as the use of the publicly available identifier. So DAO LLC is an extension to our LLC, but a DAO, if they really wanted to, could form under almost any state's LLC laws. We just make it easier for them to do it here and more attractive for them to do it here. The publicly available identifier is frankly, I think the only really dividing thing of what they'd have to require in a Dow LLC versus a regular LLC. But we're really only doing it as a matter of a way for the public to identify that this DAO on the blockchain is actually related to this LLC. And you can prove that because we verified that they filed it with our LLC with that publicly available identifier. If they don't have the identifier, that usually just means that they're trying to do the LLC before they create the blockchain product. But in essence, there is no real requirement. If they wanted to file a DAO under a regular LLC, they wouldn't have to have this publicly available identifier anyways. So in essence, I don't think that there is any real risk of bad action than what could already be done under a regular LLC.
Good point.
Mr. Kaufman, that's actually a really good point. Maybe you could elaborate on just a little bit. You know, I'm looking at, so like on page 4, for example, the subsection A language that tells us that the LLC Act applies it already in general. But to Representative Yin's point, we're the first in the nation to have a DAO specific supplement, but there are DAOs that are formed all over the country using a state's LLC Act. So I don't know if you have any idea of the number of DAOs formed in other states, but I think it's just important to understand. I think that's a really good point, Representative Yin, that these are being formed all over the world still, even without Wyoming's law. I think that, and they could be formed, they theoretically could just be formed under Wyoming's LLC law had we not had the supplement as well.
Mr. Chairman, that is correct. What we've talked a lot about is the fact that we attempted to create a secondary set of default rules for these entities, just like we have for every other entity type. For those that do want to form, but may not have the sophistication or capability to necessarily, build out a complex structure that complies with Delaware LLC law or whatever the case may be. So
And that's the
true.
way, and that's the way, Mr. Kaufman, I've really always viewed the supplement is if I'm a coder, a group of coders, and I want to create this organization, I need a template really for what does my organization look like? And I can look to Wyoming's template. I could create it on my own as long as I'm within the parameters of LLC law, but this is really just here's a template of what your operating agreement, if you will, would look like if you don't want to operate under complete default rules of the LLC.
Yep. Very good point, Mr.
Yeah.
Chairman.
All right. Page 5, 1713 or 1731, 106.
Yeah, thank you, Mr. Chairman. So again, slight amendment. We added some functionality regarding the articles of organization shall govern if it's provided procedures for updating, modifying, or otherwise revising the organization's smart contracts. And then there's a list of others that already exist in the statute, but one that we added that was missing was dispute resolution. So that's now in that list. Moving on to 1731-108, the operating agreement. Again, we added a little bit of clarifying language. So the section now reads, to the extent the articles of organization or smart contract do not otherwise provide for a matter described, 1731-106, the obligations, rights, and duties of the members and operation of the DAO may be supplemented by operating agreement. And then we just specify that an operating agreement may be a smart contract. We thought that was implicit the first time around, but there were a lot of questions. And so we thought it was best to make that explicit. 1731-109, management. Again, this is something I would put into that bucket of kind of clarifying language. We talk about how the management of the DAO can be vested or shall be vested in its members or the members and any applicable smart contract, or I should say contracts. And then we say all smart contracts utilized by a DAO shall be capable of being updated, modified, or otherwise upgraded. This again was an attempt by the committee from a policy perspective, just to make it clear that from a management perspective, that is one of the brilliant inventions of this entity in the first place, is that you can now delegate certain operating agreement and management functions to a smart contract, which is in effect what a lot of these DAOs are doing. But we do make a requirement that if that's going to be the case, then these protocols need to be updatable. 1731, 111. Again, Mr. Chairman, these are super minor updates here. Again, we have some clarification, getting rid of that reference to member managed in section 9. And then also this section deals with the default calculation of how members' interests would be computed for purposes of voting. And so again, we just have a little bit of clarifying language with respect to who's contributing what digital assets, assuming that it is digital assets, may not be, and how to determine those rights. Moving on to 1731, 112. So this is with respect to dissociated members. This section now reads, to the extent the information is available on an open blockchain, members and dissociated members shall have no rights under 1729, 410, which is an information rights section. So again, the policy choice here, or the thinking of the committee, was the aim of these entities is to be publicly operable, right? And so the information available to the members, the public identifier of the protocol or smart contract that they're using will be public. And so unless the entity can't provide information through those means, which is ultimately the goal, then you don't necessarily have a separate, document production or information production obligation. So again, this language was aimed to kind of clarify all of that.
Mr. Kaufman,
Yes.
I know we've had this discussion on the committee, but is there benefit to making, this there's other areas in the bill, I believe, and there was one I think we already walked through, but under this right of members provision, is there a benefit to just making it technology agnostic? You mentioned, it's very likely that we could come back in the future and say distributed, open source distributed ledger, or whatever it is we choose that to be. Is there greater benefit in the industry to specifying an open blockchain versus making it technology agnostic now?
Yeah, and Mr. Chairman, are you referencing this section specifically or just in general?
Just in general.
Yeah, Mr. Chairman, I would say it's maybe early for that. We did hear testimony at the committee that there are people looking at just, non-blockchain algorithmic means for standing up entities like this, but that's not really happening yet, at least not in the same way. And it's not being executed in a way that's as publicly transparent for the participants either yet. So could I foresee a time? Yes. But the way, of course, we've developed these statutory definitions for digital assets, smart contracts, it's a little bit difficult at this right juncture to completely unwind that.
Okay.
Just my thought, Mr. Chairman.
Appreciate it.
Moving on to 1731, 113, membership and withdrawal of members. Again, we just clarifying the default rule again. So this section now is, except as specified in subsection D, a member may only withdraw from a DAO in accordance with the terms set forth in the articles, smart contracts, or the operating agreement. And this new subsection D now says, where the articles of organization, operating agreement, and smart contracts for a DAO do not specify, and then we have, sorry, I lost my spot. Do not specify the manner by which a person, and then we have becomes a member of the DAO organization. A member shall be considered a member if the person purchases or otherwise assumes a right of ownership of the membership interest or other property that confers upon the person a voting or economic right. So this is I think a pretty thorough way of saying the way in reality that a lot of these DAOs are forming is they're creating these common wallets for purposes of executing business plans on a blockchain. One of the ways that they're allowing people to join and contribute is by contributing digital assets through that wallet. So this is a way of saying that we're going to make sure the entity has a way to measure what that person's contribution is. And then subsection 2 says withdraws membership from a decentralized autonomous organization. The person shall cease to be a member if the person transfers, sells, or alienates all membership interests or the property that confers the person. So in other words, it enables them, if they get rid of that token or governance token or whatever it is that they're using on the blockchain and transfer that property, that can be the equivalent of withdrawing their membership. Mr. Chairman, moving on to 1731-114, under dissolution, subsection 2 there, we have a couple clarifications that the DAO can be dissolved by vote of the majority of the members. Again, just clarifying language there. Subsection 5, we have the DAO is no longer performs a lawful purpose or is no longer under the control of at least one natural person. So this is again one of those two spots in my mind that's kind of a large departure from what we had originally set out. And again, since Deputy Wheeler is here now, I don't want to speak for the Secretary of State's office, but one of the issues that we saw was, what is someone's remedy if they want to try to ask for the dissolution of a DAO? That was originally with the Secretary of State's office, which is highly unique because now, of course, if an aggrieved party wants to have an entity dissolved, you go file a petition with the court. So the aim here was to make this consistent with what we do in the context of other entities. That, Mr. Chairman, that's the bill.
Representative Zwanitzer?
Thanks, Mr. Chairman, and question for either review, but probably Ms. Wheeler. So currently we have power and statute for the Secretary of State's office to, I don't know, make an order to dissolve a DAO should they seem fit. I don't find anywhere else in our statutes where we allow this unless it's in a smart contract somewhere. But if we make this change in the dissolution statute in 5, currently we allow you by order to dissolve one of these. We're no longer giving Secretary of State office that power from how I read it. Do you have that power somewhere else? Or is it just out of your hands completely now?
Ms. Wheeler?
Thank you, Mr. Chairman, Representative Zwanitzer. Currently, in our other business statutes, there are certain provisions for which we can dissolve an entity. The only way that we dissolve it by order is with a court order. We do not issue orders to dissolve. It's very clear in the statutes as to for which reasons we can. Not having a registered agent, not filing their annual report. So the original language that was in a previous draft of this bill really put it in our hands to investigate and issue a petition, which we don't have that authority in any of their business laws. In our securities regulation in another division in our office, we have the power to investigate. Under business laws, we do not have the power. So we felt it was best if we put this in the hands of the court. Additionally, if we were to issue an order, that could be appealed to the court. So we would still be ending up with the court. So we felt this was the best remedy to go for these entities to be consistent with our other business laws as well.
Follow-up, Representative Zwanitzer?
I guess maybe it's a very broad question then, Ms. Wheeler. Thank you, Mr. Chairman. What oversight control, if any, does the Secretary of State have on these after they file then? And after the 30 days to make sure they have it in? Once they're in, if someone contacts you, you say, hey, go to the court, we don't really cover these, or do you have maybe not investigative powers, but any other powers on regulation control besides what we used to call smile and file? You know, check the box, everything looks like it's in, but we don't investigate if it's correct, or yeah, maybe a broader question on how much authority, if any, you have over these in your office.
Deputy Wheeler?
Thank you, Mr. Chairman, Representative Zwanitzer. With all filings, business filings in our office, we do not have regulatory control outside of making sure that whether it's articles of incorporation, articles of organization, or the various types that are required for the 13 business entity types filed with our office, we are ministerial in nature only. All we can do is make sure that the articles contain solely what the statutes require. That is the only role that we have with regulatory oversight over filings.
Thank you, Mr. Chairman. I didn't find that answer very reassuring. I think I'm not alone. Correct me if I'm wrong, that I have a hard time wrapping my head around all of these concepts that come to us, to this committee out of blockchain. And so I looked to the Secretary of State's office for some reassurance that you understand the details of all this to the extent that you can monitor and identify potential for nefarious actors to do bad things in a way that I can't. Can you just kind of broadly talk about, I don't want to get statute ahead of our ability as a state to properly regulate things. So I don't know if I asked a very clear question there, but comments would be appreciated.
Yeah, I
Thank
think
you, Mr. Chairman.
Deputy Wheeler could talk about all of the years that she has spent with the blockchain committee. I'm sure. How much
Mr.
time do you have? Go ahead, Deputy Wheeler.
Thank you, Mr. Chairman and Representative Washit, and I'm going to take it beyond the blockchain committee. So having been in the Secretary of State's office for 36 years, I can tell you how we have morphed in the amount of entities that we get and how the calls that we get have changed regarding entities and businesses in Wyoming, how our office has worked closely with the legislature to address issues that we find. And I will tell you, yes, it's frustrating that we don't have regulatory oversight. We don't have investigative authority. We don't have the people. We don't have the power to do that. So when we get complaints, we do look at a company and we will refer it to whether it's federal law enforcement, consumer protection, wherever we can send it to help our constituents. Now, that being said, when an entity forms, they don't have to tell us the purpose for which they are forming. And as I told you, when an LLC files, 3 pieces of information are required. So we don't know what the entity does. We don't know the purpose for their formation. However, when we get complaints, we do everything we can to address those. Now, coming to the DAO, this new entity type, just like with anything new, we have to tweak it. And the public identifier is where we have found our greatest need to modify the statutes. This is a whole new world to our office that, yes, we've spent a lot of time with the blockchain committee and it's been a great experience in learning about this new world. But for the DAO, for the public identifier, that's why I have worked closely, because we are seeing issues that we have. Shell DAOs are being formed, just like Shell LLCs. This is an area where we can kind of clamp down and help to prevent that from happening. So I hope that answered your question, and I could spend a lot more time probably offline answering far more.
Thank you. It would take a while to help me.
Vice Chairman Washit, you might just end up on the blockchain committee next year. I try to gently expose my committee to blockchain, just a couple bills here and there, that's all. Any other questions for the secretary? Oh, go ahead, Representative Craig.
Thank you, Mr. Chairman. Do we know, Deputy Wheeler, how many DAOs have been set up in Wyoming since the act took effect?
Deputy Wheeler.
Thank you, Mr. Chairman, Representative Crago. I can tell you, and the last statistics that I pulled was actually for the blockchain committee in January. So I can tell you, as of 12/31, 130 DAOs were formed. 125 of those were brand new registrations, and 5 of those were conversions from an LLC to a DAO.
Follow up, Mr. Chairman.
Go ahead, Representative Craig.
So of those 130, how many did we have an issue with on the identifier? How many of those did you have to say, oh, we need to give you 30 days, or you didn't know what to do, and and then come back and ask for a statutory change? What was the percentage that we were looking at there?
Deputy Wheeler.
Thank you, Mr. Chairman. Representative, off the top of my head, I can tell you it's between 13 and probably 20.
And out of the dozen or so, how many, do you know how many of them did they just not list a public identifier? Or did they What did they list? A website or what was what were the main issues?
Mr. Chairman, I would say it fell out into two categories. Number one, they did not list a public identifier. And there was a couple in particular that we identified as shell DAOs, that when they did list the public identifier, they listed their website address. And that was it, which we did verify and we did reject those. They had to come back with a valid one. Then we had in the other category, a handful that simply they didn't have one yet. And so we had to reject those and tell them, we gave them a 15-day grace period to get one. And a lot of them struggled to do that and they ended up being rejected. So they have to start all over again and file.
Committee? Anything else for the Secretary of State or for Mr. Kaufman? All right. You didn't leave corporations to come here, did you?
No, I didn't. It was an internal unexpected
Oh,
meeting. So
oh,
I do
okay.
apologize. I was not here when it started.
No, we appreciate you getting here quick. All right. All right, thanks. Carol, do we have anyone signed up online for public comment on this bill? Do we have anyone in the room who would like to make a public comment on this bill? No public comment on this little bill. All right. You sure, Tara, you don't want to weigh in on?
Where's Mr. Winnie when you need him?
Yeah, where is the submarine story? I'm sure it could relate. I will close public comment on Senate File 68. Committee, what is your pleasure? Moved by Representative Yen.
Second.
Thank you, Representative Zwanitzer. Any amendments on this bill? Representative Craigo?
Not necessarily an amendment, Mr. Chairman. So I'm just curious, since I'm still new, as far as drafting on the bills, if we look at page 8 in the amendment to section 113, the title in the statute is, I mean, if we're amending the title to the statute, do we also have to show that on the bill?
Representative Yen?
Mr. Chairman, I think we can confirm with LSO, but I believe they don't actually show it as underlined or amended. It just has a different title.
Thank you.
What was it before?
Withdrawal of members. Mr. Chairman, so it was just withdrawal of members. And what caught my eye was I don't really like how it reads, that particular section of the bill. It's clunky.
Mhm.
Because the old part only talked about actual withdrawal of members, which caused me to go pull up the book and look at what that particular section actually dealt with, which was only withdrawal. And now it has this one little provision about membership. All the other particular portions of the statute, including the new ones within the bill, are only withdrawal. So it doesn't really fit. And that's why I went and looked. That's what caused me to go look. And that's why I had the question about changing the title.
You're suggesting, Representative Craigo, it could possibly even fit better in a separate title altogether, or not a separate statutory provision section?
Mr.
Maybe.
Chairman, yeah, the part regarding membership, I feel like, which we don't have to do it today, we could talk about it or think about it. It's not wrong, and I think statutorily it works fine. It just reads kind of out of place. That's all. The part on membership versus withdrawal, because all the other portions of 113 deal with withdrawal.
Well, I wouldn't be adverse if you wanted to clean it up, Representative Craigo, but you probably don't want to do that. right now.
Purgatory.
The blockchain committee is a weird thing. It has 4 lawyers on it, and it could use another one, Representative Craigo. Any other discussions or amendments on this bill? All right. Representative Yen?
Mr. Chairman, yeah, I mean, I'll just speak to the reason why we have the bill, right? So we put in place this first in the country law, and with with the folks that wanted to do this. And then you just, the industry evolved a little and responded to what we had passed. And this is just to shape it to what is actually happening, and a little bit of cleanup, as well as just making it a little easier. For example, if a DAO no longer had human beings in it, what are we supposed to do? We should make it go away.
Right. Now, I'm going to speak a little bit to Vice Chairman Washit, some of your concerns, and I really do appreciate your concerns. And I think the point, 2 points that are really important. One, we already put this into law as a supplement. We're just cleaning it up. But I really do think it's important to appreciate that an individual can already form an organization of this nature without this amendment, without these amendments, and without the supplement that we passed last year. The way, and this exchange I had with Mr. Kaufman, honestly, the way I've always viewed the supplement when we brought it forward was honestly a way of somewhat replacing people like Mr. Kaufman and the need for him in that transaction. And that's really what the industry wanted, was they wanted a template that we could put in statute where they wouldn't necessarily have to engage the lawyer to help them develop their organization, that there was a clear template in statute that they could use. And so that, by and large, that's really how I viewed it. And so as we worked through the supplement and these amendments, what the blockchain committee did was hear from industry all over the country on what their organizations look like, what they want them to look like. Deputy Wheeler pointed out the numbers, and a small portion of them were conversions that had already existed and wanted to just use our supplement. But it is kind of exciting to see the number of DAOs that have formed. Representatives Wanitzer, I don't know if you have kept track of how many organizations have formed under your what was your L3? Yeah, because my series LLC woefully has filings. I don't even want to ask what they look like, but it pales in comparison to this. And I think you can sympathize with me on.
I thought I was the next big deal 14 years ago, 13 years ago. Didn't happen.
Yeah,
Maybe this is it.
I feel your pain. All right. That's all I have. Yeah. All right, Carol, will you please do a roll call vote on Senate File 68, Decentralized Autonomous Organizations Amendments?
Representative Craigo,
Aye.
Representative Larson.
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Zwanitzer,
Aye.
Chairman Olson.
Aye.
8 ayes, 1 no.
We could have the discussion on what happens when you try to refuse to vote in a committee.
Absent is an aye vote. Refusal is
It's
an
an
aye vote.
absent, yep.
Yeah.
And it comes an I vote. Yeah, exactly. Sorry, Senator Ellis. Thank you for your patience as we discuss DAOs. Welcome. We'll turn to Senate File 77, name change duration of residency requirement. And thank you and welcome, Chairman Ellis.
Thank you, Mr. Chairman. This is a very straightforward bill. I should have asked to go first. I'm actually needing to get to education. And this is a very straightforward issue. I sent you all an email last night, but this issue came to me from a constituent who moved to was living in Colorado and was married. She was in a very abusive relationship and fortunately was able to get out of it. She moved to Wyoming to start a new life. I believe she was able to restore her maiden name, but I think she's got some trauma affiliated with her given name and she wants a fresh start. So she looked into our statutes to see what it would take to change her name. And we have a 2-year residency requirement in the county before you can petition the court. This woman had an opportunity. She moved to Laramie. And so although she was almost at the 2-year mark here in Cheyenne, the clock starts all over again for her. So as a result, she will have lived in Wyoming for nearly 4 years before being able to petition a court for a name change. In looking at this issue and doing some research, we discovered that 38 states have no residency requirement at all. Of the states that do have a residency requirement, it's 6 months or less. So I introduced this bill to try and modernize our statutes to some degree. And initially I had proposed 60 days. You'll see if you looked in your engrossed version that the Senate decided to take that up to 6 months in the state. And I think that's an appropriate change. But just to give you a little bit more history, if you look at your green books, I just printed off a copy. I didn't want to bring my whole book up here. And if you look at the history of your statutes, which I always find to be super interesting, and you look at 1-25-102 history, you'll see laws 1890 to 91, which I think denotes that this has been on the law since we've been a state. So 2 years probably made sense when we lived in Wyoming in 1890. You know, a lot of people coming through. Who are these people? You know, having a longer residency probably was helpful to a court. But in this day and age, we really don't rely on that, long residency anymore. I've reached out to the Banking Association to see if they had any concerns about this. And by and large, we keep track of people through Social Security numbers. So this is really an effort to modernize our statutes, provide a little relief to our constituents. And we did have some discussion on the Senate side about, will this flood the courts with new cases? And I don't think the answer is yes. I think it's a very small number of people who actually utilize this. But for the people who do, it's important. And so with that, Mr. Chairman, it's a very straightforward bill. I'd ask that you vote aye on this.
Yeah, if your bill flooded the courts, we'd probably be creating more judgeships then. Committee, do you have questions on this bill? Vice Chairman Washer.
So are you saying they're a unique identifier? Is there a social security number?
Chairman Ellis.
I think by and large, if banks have concerns about who you are and where you are, that's the identifier they use.
Committee. Okay. All right. Anything else? Thank you, Chairman. Public comment from our agency? No. Welcome, Tara.
Good morning, Chairman Olson, committee members. I'm Tara Muir, Public Policy Director with the Wyoming Coalition Against Domestic Violence, Sexual Assault. We rise to support this bill and just echo, won't have to happen a lot, but boy, with some of the survivors who are can't shake that stalker and we can't get the evidence, whatever the criminal side of the issue is, this is incredibly important. I think it starts the conversation of what other civil remedies could we also come up with. That's it. I'm happy for questions.
Ms. Muir, my question is directly related to your work then and the amendment that the Senate made. Moving it, I think it probably was a good move from county to Wyoming. I don't really care that much about that. Ratcheting down the 2 years is why I co-signed this bill. But 60 days to 6 months, do you see, or if in the domestic violence context in specific, if we have someone who's relocating, does that cause any issues? How do you see that?
Certainly a shorter period would be better in those emergency situations. And we can talk about other kinds of remedies that's aside from this bill. So yeah, the shorter, the better for those scenarios for sure.
Chairman Ellis, how wed was the body to this concept of it being 6 months versus 60 days?
Thank you, Mr. Chairman. I think that the Senate was very comfortable with 6 months. And there was some discussion, and I forgot to mention this when I presented the bill. Are people going to try and game the system and move to Wyoming to change their name and hide from the law? I did want to add that any person that petitions a court has to give a reason to explain why they want to change their name. And the court will only issue it if they find that it's not detrimental to the interests of another person. So I just wanted to also add that additional information. I think 6 months is fine. When you think about residency requirements in other contexts, for hunting and whatnot. So I think 6 months is appropriate.
Okay. I love how sometimes the simplest of bills attract the most interesting debates. Ms. Muir.
Chairman Olson, I just wanted to add, usually when someone is having to relocate and even consider having to change their name, which is a pretty big chore, there's a lot of planning that goes around that. So if they know they're going to be moving and know where they're going is going to have this kind of time space, that's probably accommodating.
Probably not the immediate first thing on their mind when they
Correct.
relocate. Vice Chairman Washit.
Thank you, Mr. Chairman. Ms. Muir, we've heard lots of testimony about delays in our court access, and I'm assuming that a name change petition is not going to be moved to the top of the docket. So can you even get a filing within 6 months to get these kinds of changes made?
Ms. Muir.
Chairman Olson, that's a great question. We have a separate program that just does legal representation of survivors. I can certainly ask them. I know often they do these name changes as part of a custody or part of a divorce action. They'd like to be able to do it in a protection order time as well. But I can get back to you on that, see just how long the wait is.
Representative Grego.
Mr. Chairman, I may have an answer to that. Usually these go fairly quickly and you can get a setting. So they require an advertisement. And if there are no objections filed, oftentimes you'll just have what they call a ghost hearing, where the judge sets a hearing, no one shows up, they sign the order, and they'll do a bunch of those, and they'll set a bunch of those for a particular time on a particular day of the week. They'll roll through them all. These will actually happen in the time frame.
Absent being contested.
That's correct, Mr. Chairman.
Any other questions for Ms. Muir? All right, thank you. Carol, do we have anyone signed up for public comment on this bill? Do we have any other public comment? Any other public comment? All right, I will close public comment on this bill. Committee, what is your pleasure? Senate File 77 is moved by Vice Chairman Washit, seconded by Representative Prego. Amendments on this bill? Discussion on this bill? Representative Prego, you just ready to vote? Okay. Yep. I appreciate that. Carol, will you please do a roll call vote on Senate File 77, name change duration of residency requirement?
Representative Craigo.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
Vice Chair Washit.
Aye.
Representative Yen.
Aye.
Representative Zwanser.
Aye.
Chairman Olson.
Aye.
9 ayes.
Chairman Ellis, you did better than my bill, and it's my committee. Good job. Thank you. All right, committee. We have a few more Senate files I'm sure we'll be working through this week. We'll be working on setting an interim meeting for next week. I'll be working with Carol and Chairman Nethercott to do that. Please be thinking about your interim topics and feel free to bring them to me and to submit them so that we can make sure we get a good interim setup.
Who's going to manage this on the floor?
Oh, probably Representative Representative Craigo is a co-sponsor. So one of us will figure it out. All right. Thanks, committee. Representative Yin, are you okay to